think that's a fair assumption to make. Okay. So yes, that is that's going to say that subsection C exception is going to save that. Let's look at okay, that's subsection C. Let's talk about 4B and 4C. How about Paul's testimony? Can Paul's testimony be used to save Rhonda's gift? You think so? Okay. And I think you're right, but I think Professor Byer would think you're wrong. Okay, go ahead. Let's hear your reasoning on this, which probably is correct.
I would think the fact that it's signed on there attesting that at the time of the signature, she was of sound mind and capable of doing it. That creates testimony in and of itself of a disinterested and credible person.
Well, disinterested and credible person, the person in subsection D means someone who wasn't a witness to the will, someone other than a witness. Paul was a witness to the will. So if I tell you, it's not the answer to 4B is, I think, yes, but not because of subsection C. How could we say that her gifts can be saved, Rhonda's gift can be saved, but not because of that exception in subsection C? What other exception applies? They're friends, so it's not subsection B, so that leaves what? What other exception do we have? Otherwise be established. It's the exception that's embedded in subsection A. If the will in subsection A, and the will cannot otherwise be established, it can otherwise be established how or why. Look at 256.153, 256.153, and just be patient on page 226. Page 226 of your statutory supplement, and this you're going to have to be patient. This is going to take a little bit of explaining, and you may not agree with it. All right. Subsection A, an attested will produced in court. It is not self-proved. It's not self-proved. Here's how you prove up the will. Subsection B, a will described in subsection A. If it's self-proved, we might, if it makes it better or makes it worse. A will described by subsection A may be proved by the sworn testimony or affidavit of one or more of the subscribing witnesses to the will taken in open court. So we need two witnesses to sign the will. In theory, they both have to be credible. But we can prove up the will in court by the testimony of only one of those credible witnesses. Is Paul a credible witness? Because he doesn't take, and if Paul will, because he doesn't take under the will, yes. And if Paul will appear in court and prove up the will, you don't need both of the witnesses. Therefore, the will can be otherwise established. Wow, that's pretty tough. I'm going to tell you this. There are cases on that. There are cases that hold just like that. Right on point. Where there are two witnesses, one of the witnesses was incredible, wasn't credible because one of the witnesses was interested. The other one didn't take under the will, wasn't interested. A non-interested witness could appear in court to prove up the will, and that would say the entire will, including the interested witness's testimony. Professor Byer doesn't think that's enough. Professor Byer thinks that in number 4B, the answer is no. Paul's testimony can't be used. I think he's wrong because Professor Johansson, who is the guru, the granddaddy of literally and figuratively, probably of all the wills teachers in this state, his commentary in his annotated probate code cites two cases that hold just exactly that. Those are the facts in 4B held, and there's one interested witness that can appear in court and testify. That's good enough, even though the other witness or other witnesses are all interested. One disinterested witness can appear in court and testify. Credible, disinterested, even though the will was signed, all the other witnesses were interested, their gifts are upheld. The will is valid because we have one disinterested witness who appears in court. It doesn't necessarily, the statute doesn't necessarily say that. That's just the judicial interpretation of the statute. So the answer to problem 4B is yes, under 254.002 subsection A, except as, or as the will cannot be otherwise established, and the will is otherwise established by one disinterested witness, in this case, Paul, appearing to say Rhonda's gift. But I do want you to know, Professor Fire does not think the answer to number 4B is yes. He thinks the answer is no. Professor Johansson thinks it's yes and cites case authority, so I'm going to assume that Professor Johansson is right for our purposes on our final exam. Okay? That's what we'll say. Question about that one. Now we got a worse one. Assume that Rhonda and Esther were, both of the witnesses were interested witnesses. Both of them weren't credible. So we don't have the 4B situation. May Carla's testimony be used to save both of those gifts? Either or both of those gifts? And then we're going to ask what happened to Carla's death. What do you think? Can Carla be used to say the will is signed by 0 credible witnesses? Can Carla's testimony be used to save both of those gifts? What do you think? Yes? No? Maybe? Mr. Lincoln?
I think, yeah, I
Yeah.
think she can.
Yep. And what's your statutory authority for that?
Maybe 256 1.153.
Well, no, I don't
No.
think we have to get there.
Okay, well,
It's
yeah.
0.002.
Then section C.
It is. It's subsection C.
Okay,
That's
so
right.
one disinterested.
We've got one disinterested person. Disinterested person in subsection C who's not a witness. A disinterested person. Now, what if Carla's dead? Can we just be saved? Well, Mr. Moran, might you need more facts? So, what are some of the facts you might look for in problem 4C? Carla's dead. She supervised the will ceremony. She could have testified. She could have corroborated these 2 interested witnesses in 4C. But she's dead. What else might you like to know?
Did she bring any of her staff?
She's bringing any of her staff with her, right? Was the notary with her? Was her secretary with her? Were any of the other attorneys in the room or something like that? Even if they weren't a signing witness. Even if they weren't supervising the will execution ceremony. If any of those other people were there, and they could appear to testify and corroborate the testimony of these 2 interested witnesses, then we could say that. You do need more facts, right? Mr. Lincoln, you were thinking the same thing, probably.
Yeah.
Sure. I can read your mind. Okay. So that is how these work. What do you think about this? Questions about this so far? And then I got a couple of typos to run through with you to show you how this works. Going back to B.
You said there was, I think you pointed to the section on page 226.
Yeah, I did. I did. That's it. I went to the statute on page 226. I went into 256.153, subsection B. The will described by subsection A may be proved by the sworn testimony or affidavit of one or more of the subscribing witnesses. One. So to prove a will in open court, we only need one subscribing witness. So if one of the subscribing witnesses appears to prove it up and is disinterested, 4B, that'll save the interested subscribing witnesses, attesting witnesses, share. Now, gifts under the will. Professor Beyer doesn't think the will. He thinks the answer to 4B is no. Professor Johansson thinks the answer to 4B is yes. Professor Beyer actually, in some of his treatises, one of his treatises actually cites an early case saying the answer to 4B is no. Professor Johansson cites 2 more recent cases that say the answer is yes. I'm going with Johansson on that. Yeah, you go with Johansson on that for our purposes. In real life, do the research. There's no guarantee that the answer to 4B really is yes. There is if it comes up in December on the final exam. The answer is yes for the reasons that we've just talked about. Other questions? All right, let me say a couple more things about the purging statutes. You'll probably get a purging statute. You're spending a fair amount of time on it. You'll probably get like one question on the final exam on it. It's not going to be a big question probably, but you might get a multiple choice question or you might get a short answer question or something like that. Note 5, may the executor of the will be one of the witnesses? Why would you think an executor couldn't be one of the witnesses? What's wrong with an executor being a witness? What's wrong with the person who takes under the will being a witness? What's conflict of interest, and therefore they might not be what? What's the word? Honest? What? Credible. Credible. That's a statutory word. Credible. Credible. Okay. So, it's a conflict of interest. Why might it be a conflict of interest? What's the executor getting? Why might the executor be interested and therefore not credible? What? They might get a fee. Yeah, they might be getting a fee. We don't know. We need more they might be taking an interest under the will, but then they're going to be thrown out, and there's going to be acceptance because they are interested, not because they are executors. So the question in number 5 is the fact that the executor is named in the will, does that make the executor an interested or not credible witness? The early cases seem to hold that the executor can't be a witness or the executor would even be not credible. The later cases hold if that's the only thing that the executor has. The only thing he's taken under the will is his position as executor. He is not an interested witness. He is not an incredible witness, and therefore he can be a witness, just like anyone else. The purging statute doesn't apply to the executor. If he's also a beneficiary, that's a different story, right? So now, well, let's look at. I got a couple of hypos. So I want to look at a couple of hypos. Then we're going to come back to question 6 and see if you think we should do away with the purging statute 254.002. Here are the hypos. Okay. Who wants to help? Want to hear the hypo first? No, because I'm going to give you the hypo, and then someone's going to say, "Can you repeat it?" So some bold person. God bless you. Thank you. Some bold person was going to say, "I'm willing to do this." Okay. Get ready for this. Remember, this is based on 254.002. Suppose testator's will leaves a legacy to, this is not testator's X, okay? All right? And the witnesses are Y, who's X's husband, and Q. These two people take nothing under the will. X takes something under the will. X is married to Y. Is X's gift purged, or do we have to find an exception?
It's not purged because in Texas, why, if it's given by the will, it's separate property.
It's X's separate property. It's not even Y's property, but Y is married to X.
But in Texas, anything given to X under a will, even while married, is separate property.
And what does the statute say? I think you're exactly right. You're 100% right, and that's the reason why you're right. But listen, let's go back to the statutory language. 254.002, I'm on 213. You're exactly right. Okay? Except described by subsection C, if the devisee under will is also a subscribing witness. Is the devisee under the will a subscribing witness?
No.
Okay, it's the devisee's husband, and that would be the devisee's husband, Y's, or it would be X's separate property. He's not a devisee under the will. He's a witness. We've got two credible witnesses here. The reasons, the policy reasons you say 254.002 doesn't apply. The purging statute doesn't apply to that at all. Okay, now, that's because the courts have construed the purging statute very narrowly. Okay, gift under a will is in cases that hold a gift under a will to the spouse of one of the witnesses doesn't apply. That doesn't have any effect on the gift under the will to the spouse. It's not Y's gift, it's X's separate property. Exactly right. Okay. Same fact. C leads to X. X and the witnesses are Y and X's fact are Y, who's X's husband, and X. Now X is an interested witness. What result?
Okay, well then it would be the same result as using 256.150.
You're exactly right. It's the same result as problem 4. Wait, no, it's not problem 4. It's the same result as problem.
Yeah.
Which one did I give you?
4B.
No, it's 4. Yeah, it's 4B. It's 4B. I was not 4B. Yeah, 4B. Exactly right. 4B. It's the disinterested witness. Why? Disinterested witness. Xerxes and Xerxes and Xavier. Xerxes' testimony could be used because we own 256.153B. We only need one disinterested witness, and this is a disinterested witness. Except that he's married to her and she's taking under the will. Isn't he going to be tempted to lie? Maybe, but
Yeah,
it's her separate. It's her separate property, right?
Yeah.
He's not taking anything under the will. She's taking something under the will. It's her separate property. Now we've got one credible witness who can appear in court, 256.153, subsection D, which is same as, it is 4B, right? Problem 4B, it's the exact same answer. See how narrowly, thank you very much, I appreciate that. You see how narrowly these statutes operate? They really are what we call, this is just kind of a cliche that we use in this area sometimes. They tend to be a trap for the unwary. They tend to apply, they tend to purge in very limited instances and only when someone really screws up badly. So, yeah.
No, I'm assuming that if the appointed party can prove that there's some kind of corroboration for fraud between the husband and wife in the decision, then that would be considered invalid.
Well, that might invalidate it. That will never happen on my final exam. Okay, it will never happen on my final exam. I can trip you up enough on the final exam without throwing that one in. But you're maybe up. If there's some kind of fraud, if X is paying Y off or something like that, yeah, that might be a different story, right? If the contesting party was standing can prove that, yeah, that's possible. But, we're not going to see. Fair question, but won't happen. Okay. So, back to question number 6. Here's my question to you on page 105. Did Texas adopt a provision like Uniform Probate Code provision which authorizes the signing of wills by interested witnesses? What do you think about that? If the original policy behind the purging statute was sound, don't tempt a witness, the subscribing witness, to lie about whether the will was duly executed or whether the testator was of sound mind or under undue influence, duress, fraud, something like that. Don't tempt the witness to lie because it's in the interest of the witness to do so. But there are so many exceptions to the purging statute, as you've seen, it's a trap for the unwary. It rarely applies. It's the time for us just to go ahead and abandon this rule because it applies so infrequently, and it will just, the few times it does apply, it's going to frustrate the testator's wishes. After all, the testator wanted this witness to have something under the will, and the testator obviously didn't care that they were a witness. Why should it matter?
Doesn't the Uniform Probate Code had it already done away with it? Several states are going that direction.
Some states are going in that direction. Okay, and some states are actually going with notarized wills, so you don't even have to have witnesses. You know, the only problem would be if the notary was one of your beneficiaries, right? But we don't have that. We don't have that here in the state. Should we adopt that? Should we dispense with the need for witnesses? Should we allow notarized wills? Should we say an interested witness can sign because we don't care? It's just going to be so infrequent that the statute applies. We just go ahead and do away with 254.002, change the rule. What do you think? And no, why not?
Because I'm a lawyer and I need to litigate.
I mean, I wonder if the old policies of fraud are as common as they used to be, and I mean, we can likely presume that this person wanted their property and belongings to go to wherever they're going to, so.
I mean, I wonder about Ms. Garcia.
Well, I was saying, don't most people by practice, if they're gonna get a will, have it notarized anyway, so that person becomes.
The notary can become one of the witnesses, and it might be a third, witness,
Yeah,
or the
okay.
notary might be corroborating the disinterested person under subsection C, right?
Right, so it's
Yeah. So it might not matter at all. Yeah. So what do you think? Go ahead and repeal the statute. This is a trap for the unwary. We like the litigation. More work for lawyers. So. All right. Well, that leads us into the next point on page. So this has been what? This has been how long? It's just under an hour, and we've done almost a full page. But there are a lot of problems. Okay, it was time well spent because you will definitely get a question about the purging statute or an exception to the purging statute somewhere on the final exam. Drafting attorney as a witness. The point of that first couple of paragraphs there on page 106, the excerpt from Ethical Opinion 360, that recent opinion, March of 1972, when I was in high school. That was a good year. It's not unethical for the drafting attorney of the will and or the drafting attorney employee to be a subscribing witness. It's a different story if the drafting attorney or the drafting attorney's employee is a beneficiary under the will. Not if they're a witness, but if they're a beneficiary, that gift might be void. And we're going to discuss there's a special rule for that. We'll discuss that later in the semester. So just hold that aside. For now, the drafting attorney or the drafting attorney's employee, not unethical to them, they can be witnesses to the will. All right, page 106, self-proving affidavits. Let's talk about self-proving affidavits. Let's look at 251, 104, and 251.1045. 251.104 and 251.1045. You can't read that very well. Sorry. This is 1045, which was added 4 years ago. And these talk about self-proving affidavits, SPA, self-proving affidavit. And I want to talk about self-proving affidavits and how they're different from attestation clauses. Attestation clause, you've already seen an attestation clause and a self-proving affidavit. We're about to see self-proving affidavits. Now, 251.1054 allows the two things to be combined. Let's talk about the difference between an attestation clause and a self-proving affidavit. How are they different? And let's look first. First look at this. Let's look in the sample will, the end of the sample will. We look at the attestation clause, page 482 and 483, and the self-proving affidavit is page 484 and 485. So let's look at the attestation clause. This is where the witnesses sign. This is what the witnesses are signing to. This is what they said. The foregoing instrument consisting of this and blank preceding pages was signed, published, and declared by the testator to be his or her will. Last will, we now, at his request and his presence, subscribe our names as witnesses stated. We've initialed each page, and there they sign. Okay? Does that satisfy 251.051's requirement that an attested will be signed? There be at least 2 subscribing witnesses. Yes, sure. 2 people sign. Yes, that's fine. What are they saying? 251.051 says that those attesting witnesses have to sign their full names in their own handwriting. They can't make their mark, or they can't have a proxy sign for them whenever. Well, their names. Does that mean their initials, names? In their own handwriting, in testator's presence. Does the attestation clause say they signed in testator's presence? What does it say? We now, at his request, in his presence. Okay, so that raises the rebuttable presumption that they signed in testator's presence. Subscribe our names. How about this? How about that first sentence of the attestation clause? That this will, to this page, was signed, published, and declared by the testator to be his last will. What's the difference between publication and testator declaring this to be his last will? What's the difference? Is there any difference? That's it. That's publication. Publication is, I declare this to be my last will. Is there any requirement under 251.053 under our Wills Act that testator publish the will, declare it to be his or her last will and testament? No, we saw that last week. In the case now, but we saw that last week. The Davis versus Davis. Davis versus something. There's no publication requirement, but the attestation clause includes that. The standard attestation clause does, not all of them will. So how is that different? Look at page 484. Let's see what a self-proving affidavit does and how it's different. Before me, the undersigned authority. Who's that talking? Who's the undersigned authority? The notary. Exactly right. On this date, personally appeared the client, that's the testator, and the 2 witnesses known to me to be them, whose names are subscribed or annexed to the foregoing instrument, the will, right? In their respective capacities, all said persons being duly sworn, all 3 of them. They declared to be, and the testator declared to me and the witnesses, in my presence, that the instrument was his or her last will and testament. That's publication. Is that required under the statute? No, there it is. And that he or she willingly made and executed as her free act and deed. Free act and deed, what does that seem to indicate? Free act and deed? What? It's what? It's voluntary, and therefore what? We haven't gotten to it, but what about testamentary capacity? What if it's not the free act and deed of the testator? What does that say about testator's testamentary capacity? It might be fraud or duress. There might be a problem, and that's when we get to will contests later on. You asked this question last week. Can't you challenge testator's capacity if it's fraud or duress or undue influence. Yes, you can, but for some reason, Professor Byers saves it for a different chapter. You could have done it earlier in this chapter when we talked about the testamentary capacity. Okay, free and voluntary act, free act indeed. Therefore, it's not under duress or undue influence. Let's see. And the said witnesses, each on his or her oath in the presence of and hearing of the testator, said that the testator had declared to them that said instrument is his or her last will and testament. That's publication again, and that she executed saying in section 1, each of the signed witnesses upon their oaths, each witness stated further they did sign their name in the presence of testator, right, at his request. That's what they got to sign in the presence of the testator. That the witness was at least the testator was that he, that's the testator, was at the time 18 years of age or over, or being under such age, was or had been lawfully married, or was then a member of the armed forces of the United States and auxiliary thereof, or the maritime service. Why is that in there? As testamentary capacity. That's 251.050.001. We can execute a will, right? The legal capacity. And the testator declared, and that was the testator declared that he was of sound mind. That's also necessary in the 251.001 for legal capacity. And that each of said witnesses was then at least 14 years of age. That's required under section, what? Witnesses have to be 14 years of age. 251.051, the Wills Act, says there has to be 2 credible witnesses at least 14 years of age. So some of the stuff is in the statute. Some of the stuff like publication isn't in the statute. It's just extra. It's in there because in case there's a problem as to whether the testator knew what he was doing. Right? That's one of the tests for soundness of mind. The testator knew what he was doing. Did he know he was signing a will? If he said he was signing a will, here it is. Okay. Subscribed and sworn to before me, that's the notary just like that. Okay? So, what's the difference between an attestation clause and a self-proving affidavit, other than the fact that the self-proving affidavit just has more words? What's the difference? It's sworn, and why does that matter? The attestation clause is not sworn to. Self-proving affidavit is sworn to. Why might that matter? We'll go through the statute in just a moment. Just in lay terms, why do you think that might matter?
If it comes up to be contested, that's a form of testimony.
It is a form of testimony. If the will is contested, if there is a question later on about whether the testator was of sound mind, whether the witnesses really signed in testator's presence, whether the testator signed the will, or it was a forgery or not, whether the testator knew what the testator was doing, whether this could be my will. If that comes up, the attestation clause and the self-proving affidavit both provide prima facie evidence that those things happen. But the difference is the attestation clause is sworn to, as you said, Mr. Brown. But the self-proving affidavit is sworn to, and because it's sworn to, as we're going to see in a second, the statute says if the will is self-proved, you don't have to call witnesses to prove out the will. The will can just be produced. Because it's already been sworn to, because the witness has already been sworn to. It's an affidavit. It serves as testimony. It substitutes for testimony. Attestation clause isn't sworn to. It doesn't substitute for testimony of the witnesses. So self-proving affidavit does dispense generally with the need to call any witnesses to prove up the will. You can introduce without witnesses appearing in court to prove up the will. A will that doesn't have a self-proving affidavit can't be. One or more witnesses are going to have to appear in court to prove up the will. Or we're going to have to find, or we're going to have to satisfy the court as to why we can't provide one of the witnesses if we don't have a self-proving affidavit. So can you see why it is a standard practice and a good practice to include a self-proving affidavit in the will? Dispensing with the need generally to call witnesses to prove up the will. Look at 251.
Professor, what is the
251.102. 251.102. Page 206. 251.102. Subsection A. A self-proved will may be admitted to probate without the testimony of any subscribing witnesses. The testator and or the testator and witnesses execute self-proving affidavit, or if the will is simultaneously executed, tested, and made self-proved as provided by section 251.1045. 251.102 subsection A says that it's either 251.104, self-proving affidavit, or 251.1045, combined attestation clause, execution, self-proving affidavit clause, then we don't need witnesses to prove up the will. It also, and Ms. Brown, I promise we'll get back to your question in just a moment, 256 also tells us that, and 256 point, 256, 152. Okay, on page 226. 256.152 and 256.153. Look at 152, subsection B. 256.152, subsection B. I'm on page 226 of the statutory supplement. I'm going to read it in the pertinent part. A will that is self-proved, as provided by subchapter C, chapter 251, now down to the bottom of that paragraph, is not required to have any additional proof that the will was executed with formalities and solemnities and under circumstances that are required to make the will valid. No additional proof. The witnesses don't have to appear. And 256.153, subsection B, 256.153, subsection B. We looked at A before. Subsection, no, it's not self-proving. That's not it. That's not what it is. 256.153B. No, that's not it. Okay, yeah. Now I'm losing. There it is. That's not right. I wrote down the wrong statute number. So 251.102A, 256.152, and some in fact, it's 256.152B. Those are the two sections. Okay, I think I got it right now. That show you that self-proved will does not need any witnesses to be proven in court. It's just a sort of program. Okay? Now, questions?
Does the notary stamp, or the fact that the notary signs, does that become testimony also?
Some testimony?
I'm wondering, when we went back to the question of the perjury statute, since she's not subscribing with witness, would the fact she is notarizing it, swearing to it, does that become testimony?
Yes, well, she could be a disinterested person who could corroborate the testimony and save the otherwise purged interested witnesses. Yes, the answer is yes. But why do you think that the statute? I can tell you what, I'm going to stop you right now. I'm going to say you come up and talk to me after class, but we're going to confuse everyone else. And I don't want them to miss this question if I'm going to do it. Because it's a very, very, very good question you asked. You're asking a great question. Okay, but let's talk about it offline. Okay? Thanks. Okay. What else do I want to talk about? Okay, I think that's probably all that I want to talk about here. Other questions before we do some of these notes? Okay. You're looking at time. You only 5 minutes.
No.
Sure you do, don't you?
No, we don't.
You think that's tax real property? Wait. Are you my tax real property? Okay. And you all owe me 5 minutes, but I even it up today, right? So we're even today in tax real property. But you've
been even in here.
I've been even in here, really?
Yeah.
You actually got less 5 minutes.
Okay. Nice try.
You've asked
Nice
every
try.
single time.
Yeah. Nice try from the guy who was in Wendy's takeout line last week, but that's a drive-thru line last week, but that's okay. You know, because you look like Paul Giamatti and you shaved off the beard. I need to give you credit. You'll take it. Okay, thank you. All right. Let's look at the notes afterwards, because I think this is really important stuff. Note 1 on page 106, would you recommend using a self-proving affidavit? Yes, because it dispenses with the need to call the witnesses to prove up the will. Self-proving affidavit, if there's a will is made self-proved, we don't need witnesses to call up to prove up the will, and have a will admitted to probate. Note 2, does self-proving affidavit require testator and witnesses to swear to things? which are not required for a valid will? If yes, what? We've already been over that. I won't ask you that. We've already been over that. 3, may a self-proving affidavit be executed years after the will was executed? If yes, under what conditions? What if the self-proving affidavit was executed later? What if the self-proving affidavit was executed a month or a year later? The witnesses were there when the testator signed it, but they just, for whatever reason, didn't make it the attorney didn't make it self-proved at the time, but a year later, the attorney comes up with a self-proving affidavit, and everyone signs it. Is that okay? Yes, it is. What's your authority for that? 251. 103. 251, 103, subsection 1 says, will or testament that meets the requirements of 251.051, the Wills Act may be made self-proof, 1, at the time of the execution of the will, or 2, a later date. How much later? During the lifetime of the testator and the witnesses. It's a case that held, I think, that a couple of years wasn't too late. Just like the will can be signed by the attesting witnesses within a reasonable time, whatever that might be. Any time, here the statute tells us, can be made self-proof at a later date, after the execution of the will, at any time during the lifetime of the testator and the witness. They all have to be alive. That might be years later. That's conceivable. About note 4. Will the invalidity of a self-proving affidavit invalidate the entire will? Held, no. Held that the self-proving affidavit is not an actual part of the will itself. Its only purpose is to act as an affidavit. It's evidentiary in nature. Incidentally, that'd be true for an attestation clause as well. It's evidentiary in nature too. 2 credible witnesses have to sign the will, but you don't have to have an attestation clause in the will. Just 2 witnesses have to sign it. That's all it says. It doesn't say in the Wills Act, 251.051, that there has to be an attestation clause. You don't have to have a self-proving affidavit either. It just makes it more convenient. Years later, when the will is offered for probate, if we're not sure whether the testator was of sound mind, or that the will was properly executed, or that the testator wasn't under influence, fraud, duress, etc., we're not sure. If we have an attestation clause and or a self-proving affidavit in there, then that will serve, as we've seen, that will serve as rebuttable testimony on the fashion case that the will was duly executed. The testator was of sound mind. So it's good practice to have those things in there. But the self-proving affidavit is not part of the will itself. Its sole purpose is evidentiary. Now, I will say this. 251.1045. Let's look at that statute now. On page 207, subsection A. As an alternative to the self-proving of a will by the affidavits of the testator and the attesting witnesses is provided by subsection 251.104. What does 251.104 provide? 104, subsection E gives us a statutory form for self-proving affidavit. It's not exclusive, it just has to be substantially in that form. Subsection E, the form and content of self-proving affidavit must be substantially as follows. It doesn't have to be identical. Substantially as follows. 251.1045, as an alternative self-proving of a will under 251.104, a will may be simultaneously executed by the testator, attested by the witnesses, and made self-proved before an officer authorized to administer oaths, like a notary, that's generally what it's going to be. And the testimony of the witnesses of the probate of the will may be made unnecessary with the inclusion in the will of the following inform and contents substantially as follows, not exclusive, but substantially as follows, and this is the combined one-step process that allows the will by signing in one place, 251.045, one place. Testator signs, and the 2 witnesses sign, and it combines the execution, the attestation, and the self-proving affidavit all in one clause. Why wouldn't you avail yourselves of 251.1045? It does everything all in one step. We'd want to do that. So why do you think we have to have a statute on point? Because that's the one that's the most recent statute. In the old days, we didn't have self-proving affidavits. We had attestation clauses only. Then we got self-proving affidavits, but held self-proving affidavits weren't part of the will. So see Boren versus Boren, where by mistake there was a self-proving affidavit, but the testator and one or more of the witnesses signed the self-proving affidavit and didn't sign the will itself. The court in Bourne v. Bourne, page 107, held historically the will was invalid. Couldn't be admitted to probate because the self-proving affidavit wasn't part of the will. So we had improved statutes on that, and sadly, I'm not finished with all this, but that's where I'm going to have to finish. You sure you don't have only 5 more minutes? What? You're sure? You're perfectly sure? All right. Okay. It's 9:15. Go and sin no more. Go your separate ways, and I will be back here, same time, same place, same bat time, same bat channel on Thursday night, when we'll pick up right here with these notes on page 106 and Bourne v. Bourne. All more notes. Thank
Warren was before, and they said that because the will wasn't signed, it wasn't working. What did I write down? Described the will,
Ms.
but they
Brand, come
weren't.
ask your question if you want to.
Yes, sir. I'm playing on.
Consistent with the affidavit, the will was not
All the way on.
And Professor, just for the record, I'm okay with getting an extra 1 year there if I confuse the rest of the class.
I understand that, but I'm not okay getting it that way.
Might you unplug me?
Oh, yes, absolutely.
Lincoln?
There you go. Let's try to be a little okay. Yeah, there you go.
Thank you.
It's a little warm, yeah.
Yeah, it does that, you know,
Yeah.
what's sharp?
It's a thick book for sure.
You're reading the back of it?
Yeah, I think he has an interesting biography.
Huh.